The idea was that, again, there was this moment between Indian removal policy and the civilization policy where things are still being sorted out. And the idea was, Indians just need time to civilize, to become more like us. And so the argument, the humane argument, if there was one, for Indian removal was that if you move Indians across the Mississippi to the west, it will give them more time to civilize. And there was a real the other part of it is that there was a concern that Southerners wouldn't respect the rights of Indian peoples if they remained in the East. And so they would continue to face depredations, they would continue to face theft, they would continue to face mistreatment in the courts and loss of life, and so it was just better for Indian people to move west of the Mississippi. You had people like Rich Joe Vann and the Vann family who was a Cherokee plantation holder, and not only was he was probably the wealthiest Cherokee in the pre-removal period, he was also probably the most wealthy Georgian in the pre-removal period. So there was a covetousness of Southerners to these very rich lands that could be used for cotton farming and for plantation slavery. And there was also gold. By 1829, there's a gold discovery on Cherokee lands. And Georgia, to protect its pecuniary interests, but not protect Cherokee interests, essentially establishes the Georgia Home Guard to both police Cherokees under the auspices of protection, but really to maintain control of gold. And so that also led to a lot of people wanting Cherokee land for a whole variety of reasons. I mean, Andrew Jackson is a slaveholder. Andrew Jackson is a land speculator. Andrew Jackson is a Southerner. And so his interests don't necessarily lie with Cherokee people. He has a lot of shared interests with Georgia politicians, with those land speculators who also want Cherokee lands. And he makes it pretty clear that he is absolutely in line with the removal policy before he's even elected. And so once Jackson is elected, it's a pretty grim outlook for Native people. Cherokees, to deal with the threat of removal, launch a kind of full-scale strike. Right? There's a PR campaign through their bilingual newspaper. They're educating people on their own rights and why they should be able to stay on the lands. But they also, even earlier than a removal threat, had nationalized their treasury. And that enabled them to hire attorneys. And so they're able to hire attorneys to protect their legal interests in the lands and in their governance. And so they launch a series of legal campaigns and attempt to use the Supreme Court to reaffirm their rights within the Southeast. George Corntassel was accused of murder of another Cherokee man, and Cherokees claimed jurisdiction, and Georgia ended up jailing Corntassel, and a writ is issued by the court, and because that doesn't fare well for the state of Georgia, they expedite Corntassel's execution. And once he's dead, there's no case. And I think from a legal standpoint, Cherokees are looking for other cases. But from a social standpoint, that's a pretty scary possibility for everyday Cherokee people in terms of what they can expect from living in the South within a jurisdictional control of Georgia. The next case is Cherokee Nation v. Georgia. And that case, was both problematic, but it's also a problem because the court essentially decides that Cherokee Nation can't bring suit. They're not a foreign government. They're a domestic dependent nation. And so, in fact, they don't have lawful standing. And so they need another test case to bring to the Supreme Court. And Marshall himself actually indicates to various parties that if the right case comes, that there is a potential for hearing another case. Cherokees look to the Marshall decisions with both a fair amount of understanding that the long-term effects have been good for Native people. They also saw the win in the Worcester v. Georgia decision as a positive one. There is a jubilation that's pretty much spreads quickly amongst Cherokee people when that case comes down. But for a lot of Cherokee leaders in the know, they know that Jackson, in fact, is not going to enforce that decision. So even though the case winds up being positive, the effects are pretty damaging. I mean, it results in removal, even though they won the case, because Jackson doesn't intend to respect the decision. The Cherokee Nation v. Georgia's decision is a mixed one, because on the one hand, it still leaves a door open for continued litigation. And so there is still momentum to continue moving forward. On the other hand, it's a paternalistic decision. It's a decision that minimizes the rights of tribes in many ways. That what will their legal standing be in this young nation? And that isn't fully clear from that decision. So on the one hand, it's a case that allows the Cherokee Nation to move forward, and on the other hand, it's a compromise decision in terms of what will the status of Native tribes be moving forward. When the state of Georgia says that missionaries need permits in order to live and work in the Cherokee Nation, they're U.S. citizens. They shouldn't have to have a permit to work in the Cherokee Nation. And so the Worcester v. Georgia decision enables them to have the right parties, in the case of the missionaries, and to continue the kind of same line of reasoning to establish the political autonomy of the Cherokee Nation within the boundaries that Georgia claims. Samuel Worcester is a missionary within the Cherokee Nation who has been working diligently to help evangelize and convert Cherokees to Christianity, but he's also grown a certain fondness for Cherokee people. He's working side by side with them, including Elias Boudinot, who is the first editor of the bilingual Cherokee Phoenix. And so he is somebody who is invested both in his own mission to convert Cherokees, but also invested in the community. So for both of those reasons, he objects to being told that in fact he cannot do his work within the Cherokee Nation, and he's willing to risk himself in the courts in order to go to bat for Cherokee people. The state of Georgia, in an attempt to crack down even further on Cherokee people and make their lives a little more miserable, decides to do so through the missionaries. There were a plethora of missionaries within the Cherokee Nation from a variety of denominations. And so what Georgia demands is that all missionaries receive a permit from the state of Georgia in order to work and or live in the Cherokee Nation. And so this gives the missionaries an opportunity to bring suit against the state of Georgia and act as a plaintiff in a case that can go then before the Supreme Court. They wind up being the right plaintiffs, whereas the Cherokee Nation in the previous case had been the wrong plaintiff. Samuel Worcester goes to jail. He winds up being sentenced because he resists this permit law and simply doesn't apply for his permit. He continues to do his work and live and reside in the Cherokee Nation, and he's ultimately arrested and sentenced to hard labor within the prison in Georgia. And he writes back and forth. He's constantly advocating throughout that period through letters and through correspondence on behalf of the Cherokee Nation. And he simply acts as a kind of continued ally, even though the conditions under which he's incarcerated are quite bad. So the legal case he launches is Worcester v. Georgia, and that case enables him to make an argument that the Cherokee Nation gets to determine who, in fact, enters and works in their own community. And so if the Cherokee Nation is a political body that has its own self-determination and autonomy, then, in fact, he's not answerable to the state of Georgia in terms of his work and living conditions. And so it forces the court to make a decision on Cherokee political sovereignty within the boundaries of what the land Georgia claims. Marshall rules that, in fact, the Cherokee Nation is a domestic dependent nation, that in fact they are both a political body that has not given up its rights to self-determination, even though through certain treaties they may have given up rights to, say, interact with foreign governments and make pacts with foreign governments. But in fact, they have a continued right to exist as a nation within the boundaries of the United States. And that additionally, the United States is bound to protect those interests as a ward, as a guardian would to its ward. And that language, it gets turned on its head at a later date, but in the spirit of the moment, the idea is that the federal government has an obligation to protect those native nations that exist within its boundaries, and that they have to protect those political interests as well. So the case actually upholds native sovereignty within the United States and the rights of tribes. Georgia is no less emboldened at that point. There is very little legal protection for Cherokee people. There is very little effort to protect the interests of Cherokee people. Georgia, as well as some of the other southern states, have already subjected to Cherokee people to the laws of the state. Cherokee people cannot bring any cases to the courts of Georgia. They cannot act as witnesses on their own behalf. So they really have no recourse if anyone does harm to them, including the state of Georgia. And this is, it doesn't stop any of their plans, in effect. They simply enable regular, everyday people to do harm to Cherokee people with basically no consequences, which is what essentially happens throughout this period. The state of Georgia also has a great relationship with the president in office. And so there is a sense that there's no real recourse for the Cherokee people, that the case may have gone in their favor, but there has to be an apparatus to actually carry out that decision. And John Marshall lacks that. And so without that, the state of Georgia and the federal government kind of press forward with trying to make a treaty with the Cherokee Nation to remove. And obviously it's the federal government's responsibility, but Georgia is very much pressuring treaty making to continue to get Cherokees out of the state of Georgia. Cherokees go through a whole variety of means of continuing to object. They continue to appeal their case. They continue to live their lives. They continue to farm and do as they please. They continue to have internal debates about what should happen next. Unfortunately, during this period, up until that decision, there had been pretty much uniformity amongst most of the political elites that they were going to collectively resist removal. Two parties in particular, Elias Boudinot, who was the editor of the Cherokee Phoenix, and his cousin, John Ridge, son of Major Ridge, are both in the Northeast when that decision comes down. And they are very aware that Jackson has no intention of actually enforcing Marshall's decision. And so those two men in particular are prepared to have a different kind of conversation about removal. They want to come back to the Cherokee Nation and have that conversation with the community. John Ross is still adamantly opposed to removal, as are most Cherokee people. And so John Ross's principal chief, regardless of what his personal opinion on removal may have been, still had to answer to Cherokee people who were by and large in complete opposition. That changes over the course of some time. The Cherokee Nation political leaders begin to kind of play around with treaties. There are several drafts of removal treaties that are in the works. But I always think about this as a resistance too. Like, how do you slow down bureaucracies? You slow down bureaucracies by actually using them. And so every time you make a draft of a treaty, it's going to have to be negotiated. And that process bides Cherokee people time. By 1835, there's real discontent amongst a small body and a vocal body of Cherokee people, including the Ridge and Boudinot families. And so even though none of them are in an official position to make a treaty with the United States, they forge an unlawful treaty with the United States for removal. And The U.S. government is fully aware that that treaty is being made by parties that don't have the power to do that, and it's brought to Congress. Congress passes it, and the president signs it. And that is essentially the final nail in the Cherokee coffin of living in and remaining in the East. However, that doesn't mean that Cherokees don't continue to resist in a variety of ways. John Ross launches a petition campaign, and he essentially sends people out to all parts of the nation to get signatures from every Cherokee person in opposition to that removal treaty. It's never actually presented to Congress, but there's a document with 16,000 signatures, many of them in syllabary, sitting in archives with that effort. John Ross also encourages Cherokee people to continue living their lives and farming as they always would, even after the deadline is beginning to approach for removal westward. And by the time of removal, there is more people perhaps thinking that they should remove. So there's a small body of people that in 36, the Treaty Party in particular, but other people as well, that do ultimately remove before forced removal from 38 to roughly 1840. So Cherokee people do a variety of things. They engage in political activism of other kinds. They continue to live their lives. They continue to use their political elites to hopefully stave off removal. John Ross continues to oppose the treaty. He actually proposes at one point a different price tag. He says removal will cost $20 million, which of course is outrageous in the minds of Congress, and they object to it. And so ultimately, when soldiers arrive, most people are not prepared for that. So the approximate number of people forcibly removed is about 16,000. And of those, there are debates about the loss of life. Best estimates are around 4,000, so a quarter population loss. And I think those numbers don't force us to reckon with actual people. That if we think about what that means, it means every single family loses someone. And that also means that no one's protected. In particular, I think we have to think about who is harmed by a journey of that kind. So the young and the old, the babies who should be born or are born are particularly vulnerable. And the elderly, our tribal historians, our tribal wisdom keepers, our medicine keepers, they're also particularly vulnerable during this journey. And I always think about those particular individuals had the best ability, I think, to have said to Cherokee people, we have survived other things and we can survive this too. And there's a loss of that voice in the community when you lose your elders. I also think that there have been good demographers who have reminded us that what does ethnic cleansing do to a people? It means that the relationships that would have formed had this disruption not have occurred, and the marriages that would have happened and the pregnancies that would have occurred didn't occur. And so we have to consider another level of population loss, that you have natural population increase being stymied and stopped in its tracks. And Cherokees throughout these first decades of the 19th century were on an upward growth pattern. They were bouncing back from a really treacherous 18th century for a variety of reasons. And so populations are rebounding. And this, once again, hurts Cherokee people in a whole variety of ways. John Marshall for Cherokee people is complex. And I think for Native people broadly, he's complex. John Marshall does an attempt, which many had not attempted to do up until that point, of kind of thinking through what are our laws as they relate to Indigenous peoples. So he's mining printed records and trying to make sense of what is a coherent Indian policy. And there really isn't one, in part because there are many tribes that you're creating policies with. And there are also global implications for this, that many of the earliest laws related to Native people came out of the Catholic Church. And so we have the doctrine of conquest and the doctrine of discovery, and these are policies that today many indigenous people know are the foundations of continued land loss. And Marshall's willing to look at those and consider them as part of his decision making. So he's not considering indigenous law. He's not considering the complex and sophisticated legal systems of indigenous people. He's considering non-Indian people's understandings of the rights of Native peoples. And so on the one hand, we've got to give him credit for at least attempting to do something that people at that time were not considering. Let's have a consistent Indian policy. Let's think through the rights of Indian people. On the other hand, as most people around the world are, they're pretty ethnocentric. And so he's thinking through it in his own terms and can't necessarily reckon with indigenous law or Cherokee law. And on the flip side of that, these cases, particularly Worcester v. Georgia, is the foundation of tribal sovereignty today. That it's not just a case that enables Cherokee people to have continued governance. It's a case that enables Native nations across this country to exercise their political sovereignty and to self-govern. And I think we have to reckon with both of those, that these cases on the one hand set a precedent for indigenous peoples globally not being able to undo some of the damages wrought. And on the other hand, it acts as the political backstop of tribal sovereignty for all the federally recognized tribes in this country. There's a way in which you can read Marshall's trilogy of cases related to the Cherokees as somebody growing. That he's thinking through these cases over time. He's got a couple of cases to work with, and so Marshall's attempting to make sense of something that requires a learning curve. And so I think he gets some things wrong in his earlier cases that he himself is trying to correct throughout that process. And arguably you can't undo some of the decisions that you've made that are potentially harmful, but he attempts to right the course in those later decisions in a way that his earlier decisions had not. So the nullification crisis is interesting in terms of thinking about the Marshall decision, in part because we see a willingness on the part of Jackson to use troops if necessary to uphold decisions, right, that work in his favor. And that in particular, the Worcester v. Georgia decision exemplifies a moment when he throws up his hands and says, I'm powerless. What can I can't. I don't have the power to enforce, and plays around with this idea of how much power an executive actually has in this early moment of U.S. history. And so what those cases show us is that, in fact, if Jackson had had the will, perhaps he could have used executive authority in a way that he was willing to in other moments. Samuel Worcester ends up coming west with Cherokee people and continuing missionary work with them for a period of time. And not all the missionaries did. Many of them threw up their arms and left the Cherokee Nation. And I think it speaks to his continued commitment to Cherokee people as well as his allyship throughout this process, that that despite not being able to prevent removal, he's having the ability to walk away from removal in a way that Cherokee people did not, that he continues to commit to a people who faced something he in fact did not necessarily have to face.